Hello, my name is Benjamin Hart. I'm an American attorney and the managing director of Integrity Legal here in Bangkok, Thailand. So as the title suggests, and you did not read that wrong, it looks like we may, and I stress may in the future, be seeing a new rule with regard to DNA testing for petitioners even possibly, not to mention the actual underlying applicant, the person trying to get the visa, but also the person sponsoring that person. It looks like they may require DNA testing in association with future immigration benefits to the United States. Let's dig into this. I found this in the Federal Register. This is federalregister.gov. The title is Collection and Use of Biometrics by U.S. Citizenship and Immigration Services. If you read this procedurally, this is a proposed rule. It is not a foregone conclusion that they are going to do this. If you have a senator or congressman, possibly a good idea to go ahead and let them know that you don't want this to happen. Also, if you go to that federalregister.gov site, there's information about where to go to lodge your own comments regarding the proposed rule. So there are mechanisms to possibly head this off at the pass, as they say in some of my favorite old westerns. But for now, this is a proposed rule, and it's looking like if all goes according to their plans, they may implement it as soon as next year. Again, federalregister.gov under summary, the U.S. Department of Homeland Security proposes to amend its regulations governing biometrics use and collection. DHS proposes to require submission of biometrics by any individual, regardless of age, filing, or associated with an immigration benefit request. So like anybody mentioned, if you will, in the documentations pertaining to a U.S. immigration application could be pulled into this if it comes off the way they want it to. Quoting further, other request or collection of information unless exempted. So it presumes everybody and then they create specific exemptions is what they want to do. That means effectively presume it's going to be everybody. Quoting further, expand biometrics collection authority upon alien arrest, define biometrics, quote unquote, codify reuse requirements, codify and expand DNA testing, expand DNA testing. And they're saying for anybody associated with an application for an immigration benefit. I mean, this is serious stuff. And I'm sitting there wondering why. Well, maybe they just want to know. I think it's intrusive, but I'm trying to, like, in my head come up with the arguments as to why they even need this information. In a theoretical context, if a child was born abroad, I guess they'd already have that person's DNA on file to be able to use. But again, there's no really compelling reason that I can in any way see that requires them to do DNA testing. But here we are. Quoting further, use and storage, establish a quote-unquote extraordinary circumstances unquote standard to excuse a failure to appear at a biometric services appointment. Yeah, that's the other thing. I've started to see this. I think they did it prematurely on one case. We filed an I-129F for a fiancé visa, and they immediately shot out a letter that said they wanted biometrics from the petitioner, which I haven't seen in like 15 years, and they only did that on a petitioner that had a prior criminal record. They wanted to run his fingerprints again. You know, again, this applicant has no prior record. They're perfectly clean. I don't see what the issue is, but they want to now do biometrics on the American citizen petitioners who are seeking benefits like the fiancé visa in the K-1 category or the K-3 marriage visa or the CR-1 or IR-1 immigrant spouse visa categories. They want the American citizen, it looks like, to put in their own DNA and fingerprints and biometrics. This is not good. Quoting further, use and storage, establish an extraordinary and again, only allow people to be exempted under extraordinary circumstances, quote unquote, to excuse a failure to appear at a biometric services appointment. So then if you just fail to appear after they shoot out one of these notices, which you may or may not get in a timely manner, the one we got, you know, I received my copy here in Thailand the day they were having the appointment. So it's also this another sort of backdoor scheme to try to kill these legal immigration cases in such a way that they don't have to adjudicate on the merits, because they know if they adjudicate on the merits, they need to approve the petition. Quoting further, modify how VAWA self-petitioners and T non-immigrant status applicants demonstrate good moral character and clarify biometrics collection purposes. Yeah, other than we just want it because we say so for you to be able to get a U.S. immigration benefit. But this is where we are. This is going to have if this rule passes, and again, it's not a foregone conclusion. Go to the websites, lodge your own ideas on what you think of this with the Federal Register. Also, may not be a terrible idea. I don't think I've ever said this in a video, and I rarely would say it when I'm talking to clients. This issue might be something worth contacting a congressman or senator to say, hey, can we not have this? If I want to sponsor my Thai wife to come to the United States, I don't want to have to give them a pint of blood in order to do it. You know, and I don't think that's unreasonable for an American to expect that kind of treatment by our own government. So again, the only point I'm trying to make with this video is, one, this will have a substantial impact on the U.S. immigration process generally. I suspect it'll have a particularly acute effect on the fiancé and marriage visa categories if this ultimately comes to pass.